how are you, Steven?
Good, thank you, yourself.
Пані Юлія, вітаємо вас на другому етапі конкурсного відбору.
Yuliia, welcome at the second stage of the selection for the HQCJ,
На етапі співбесіди.
at the interview stage. And the stage is conducted by the full composition of the selection commission. These are Ted Zachechny, me, Ivan Mishchenko, Yevhen Mezentsev, Serhiy Varlanov, Robert Brookhuizen.
Can you please turn Роберт Брукхайзен та
And
Стівен
Stephen Markman.
Доповідачами на
Good
вашій
afternoon.
співбесіді,
Good
пані
morning.
Юлія, є
The
Євген
rapporteurs
Мезенцев
are
та
Yevhen
Тед
Mezentsev
Зачечний.
and Ted
Під час
Zachechny.
співбесіди члени комісії будуть ставити вам
And during the
запитання.
interview, the members of the commission will ask you questions. Please give concise answers because the commissioners may limit the time of your answer. Let's hope that our interview is not interrupted because of any technical reasons of power outage, but if it happens, so we will reschedule it. Before the beginning of the interview, you will have a chance to present yourself, to tell about your motivation and about the ideas that you have got in relation to the HQCJ and probably the judiciary in general. And with this, let me give the floor to Yevhen and Ted. Thank you, Ivan. Good morning, Yuliia. I'm Yevhen Mezentsev, and let me start our round of communication. And let me start with a short introduction and the CV data that we have in our materials. So our today's candidate is Yuliia Dzhepa. The premarital surname is Klitschko. She was born in 1984, and she works as a judge of the Commercial Court of Sumy region. Before that, for 7 years, she was assistant judge, lecturer. The period of her staying in the judicial position is 10 years, and her overall work record is almost 17. She's a PhD. She is an associate professor. She got citizenship of Ukraine in 2005. And the institutions she has graduated from include Ukrainian Academy of Banking. She graduated in 2005 and 2010. Yuliia got diploma of the National Law Academy named after Yaroslav Modry, Master of Law. This was diploma with distinction. Her command of English is B2 level. She's got certificate of fluent command of the Ukrainian language of the second degree, and she got it on the 30th of August 2022. That's a short introduction, and now please, Yuliia, let me give you the floor. Please tell us about your motivation, and if I have forgotten to mention something, you can add it. Good morning, dear commissioners and all those who are watching the interview with me. Thank you for your introduction. To add to what I've mentioned, I would like to say, Yevhen, that I work in the Commercial Court of Sumy region. I've been working here for almost 11 years. And when I worked assistant judge, that was in the Appellate Court of Sumy region. And I also worked in the Chamber on civil cases. And I helped the secretary of the chamber to also consider criminal cases. Before Sumy Circuit Court was established, when the Code of Administrative Proceedings was introduced and came into effect. So we can see that I've got the experience of almost 17 years of working in judicial institutions, the first and second instances, and I've experience of working in different types of proceedings. I'm a lecturer, and I started being a lecturer. I started my lecturing career in 2008, and over the recent 2 years, I've been the chairperson of the State Examination Board in the specialty International Law, which means I have the assessment and evaluation skills, and besides that, I have some communication achievements because in 2018 I was elected judge spokesman or judge speaker of the Commercial Court of Sumy region. I was elected a delegate to the Congresses of Judges many a time, and I was a member of a rather powerful media team of the Commercial Court. I've been there since 2018, and we have tested a lot of interesting projects. Some of them were even broadcast on the central TV channels, and we got into the TSN news 2 times. And I'm also the organizer and ongoing participant of briefings, workshops, seminars, trainings for students, student contests, and I train students for participation in those contests. I'm a member of the jury in such events. So as you can see, I have some communication skills. And let me also mention that my scientific articles deal with the implementation of the European norms of commercial proceedings, and I'm the co-author of the Scientific and Practical Comments on the Code of Commercial Procedure of Ukraine. Besides that, I keep improving myself all the time. I keep dealing with self-development. I'm interested in the European integration process of Ukraine because I was a member of the tourists, of the visit tourists to the Council of Europe, the International Organization on Intellectual Property, VIPA, and other European and international organizations. So this is just in brief. Yes, I think it would be right to mention that the husband of Yulia is a lawyer, an attorney at law, and now he is in the army. Yulia, it's absolutely clear about your background. What about your motivation? What do you think is most important, and what is your objective for applying for the HQCJ? Yes, thank you for the question. So my motivation consists of 2 elements, and it includes both an absolutely natural desire to improve oneself and desire of self-fulfillment, and also another element to be of use for our state as a citizen, for Ukraine to join the family of European countries as soon as possible. And since I have a good professional experience and I'm rather creative and I'm striving for the changes in the judiciary and I can overcome crisis situations, I think that I can be helpful. I've got my own vision of what the future HQCJ should be like. I think that that must be a crisis recruitment agency that will be a powerful team of competent professionals, people of integrity, who are capable of selecting new and reconsidering available staff in the judiciary to ensure administration of justice in Ukraine at the highest level possible, at the level required by the democratic standards of democratic societies, with high level of responsibility of judges both for their own professional activity and for their own conduct. These objectives can be reached in 2 ways: through optimization and correct organization of the work of this commission. And what do I see in this work? We need to quit formal approaches to assessment, and only if the level of trust, public trust in judicial institutions is high, then we can use informal procedures. I mean that the formal procedures should still be followed now. And also we should have clear criteria for selection that would be clear for the society as well. This seems to be obvious, but we need to have inventory making of practical assignments and test items, because some time has passed and they should correspond to the relevant court practice. We know that this practice is changing all the time, and it should they should correspond to our current legislation, revised legislation, and we should also apply the standard of minimizing corruption risks. We should avoid the risks of protectionism in relation to candidates and other things. And in all my scientific publications, you can trace that I've always been supporting introduction of new technologies into the judiciary, in particular electronic evidence, electronic document flow, and I think e-court. And I think that the future of the HQCJ should be the future of digitalization. Well, thank you, Yulia. I understand that as a scientist, you can talk for hours, but if you can talk for an hour and 20 minutes. But let's focus on the questions the commissioners do have as a result of an examination of information about you, because we have got some explanations, we have got the documents, and a lot of them are actually exhaustive, and they liquidate our doubt, but still I think that we need to discuss them. So first of all, here is the issue related to the cars you and your family have, and in particular Land Rover Defender Sport of 2017, which was bought by your family in 2019, and the declared value is 362,000 hryvnias, which is a small amount of money as for such a car. And by the VIN code of your car, we found this car as the one that was sold at some insurance auctions in the US, Bitfax and Compact. And the financial appraisal of this car was $13,600 US dollars, because it has a damaged frontal part. But along that, with the Bitfax, besides this amount, you have the appraisal value 28,143. So how did you buy this car, and what about customs clearance? Well, I understand that an alien observer may definitely have some doubts and questions, even because of the make of the car, so we need really to clarify the situation. I have provided all the supporting documents, including the photo, to the Commission. That's why all the things that I will tell are confirmed objectively by documents and facts. Let me explain you the following. I really bought this car from the producer Dependable Auto Sales Incorporated, which is the seller of insurance cars that have been damaged. I gave the photo of this lot. Yeah, it's actually in open access on the internet. So you can see that there is no front part at all. It has been damaged. And my acquaintances told that I should better buy this car because it will be less costly in terms of customs clearance and other things. Well, the cost at this auction is floating, which means that you do the bidding. The participant of the auction does the bidding, and the final value, the final cost was 13,600 USD, and this is the information you can see on official websites. That is the price that the seller asked me to pay, and that was the cost, the price at which this car in July 2019 was brought to the port of Odessa, and it was at that price that customs duties were to be paid, were charged. That's what we call customs clearance. And I have the duty to provide the notice about significant changes in my property status. Did you submit it? Yes, I did. And I did this right after I got the documents from the State Fiscal Service of Ukraine and the Customs Service. I immediately provided this message because I thought that this was the official document which I got in the port, because I actually already had this car in my possession. That's what I thought as a lawyer, following the terms of commercial offers. According to the NACP explanations or clarifications that were currently in effect, because now I would have to reconsider them, but back then that was really true, and I gave you the photo with the instructions I followed. So it was indicated that if a person buys a car abroad, a person must indicate the value of the indication, and it was clearly indicated that this is done without the indication and without due account of registration and customs clearance. So, like all the other costs of transportation, repairs were not included as well. Sorry, that's clear. But now, has the car been repaired? Yes. Are you using it? Yes. I've been using it up till now, and I actually had to repair it, and it took me 2 years. And you can see this from the documents because registration did not take place in July that year. The car was to be brought to a certain condition to be registered, so it was registered in the autumn of 2019. I got it in July, and I ordered it even much before that time, and it was registered in autumn. Okay, as far as Land Rover is concerned, we can at least find open data that can be verified by any person who is interested in that. In 2014, you also acquired Honda Accord of 2013, and it was 2001, and this was about $15,000 back then. You mentioned that the circumstances were the same. The Accord was also bought in America, but then you sold it at the price of $17,800 several years later, 5 years later. So why did the car become more expensive than acquired by you? Thank you for the question. As far as this car is concerned, I would say that these situations are similar but not identical, and let me explain why so. And let me explain that I'm also going to buy Land Rover at the price which is higher than $13,600 because I dealt with customs clearance and repairs. So this is going to be no less than $25,000. Yes, but you're not selling your Land Rover as yet, so don't go into that. Let's get clear about Honda Accord. I provided the documents to the Commission that in the autumn of 2013, I sold my Peugeot of 2007. And I took most of the money from the sales of that car. But as far as Honda is concerned, you remember the events of 2013, 2014. So that was a year similar to 2022 in a way, because many territories of Ukraine were invaded and people were massively fleeing Ukraine and selling their property. So I bought a second-hand used car at the price offered by the seller. But he actually wanted to have more, but we somehow negotiated on the price. But the person was leaving. It was an individual, and that was a used car with some damages. And by the way, it was not from the insurance auction. These were just some damages in the body of the car, which needed to be painted. Some rubber had to be bought, tire, and it didn't have such damages as the next car, Land Rover. But the person was leaving. And I bought this car in October, and the exchange rate of dollar for several months was going upwards. It was a jump, a leap from 8 hryvnias to a much larger amount. This is just a well-known fact. I'm not inventing this. And after the aggression and the invasion of 2014, at the beginning of 2014, it started growing, and it actually had a leap from 8 to 26 and something. So I bought the car at the point of time when the exchange rate was about 12. And the person selling the car was generally afraid that he would not ever sell anything because of this leap in the exchange rate of dollar, and he was leaving, and that's why he suggested having this price. If we take 2019, we need to realize that this was a rather favorable year, a year of well-being, when the market became stable and the prices were different. And by the way, the price difference is not critical. It's just several $1,000s, which we also need to realize. Yes, I've got it. And this is from the professional seller. In this case, it was done by the person who is a professional seller, and I cannot sell things the way he does in 2019. Thank you, Yulia. According to NABU data, you have got the land plot 445 square meters in Sumy and 1,500 square meters in Sumy region, and these facilities are not reflected in the declarations. You have provided some explanations saying that you sold the first land plot in December 2011 and the second plot on the 20th of January 2012. But in the register, they still belong to you. So we have the documents certified by the notary. So why does it happen so that you are still considered to be the owner in the registered? I've got some questions to tax authorities here because I asked them, I made a request for them to strike me off the registers. But being a lawyer, I can explain this situation in the following way. I always sold everything in the open. I mean that these plots are in rural area, but that's not important. These are the areas which I inherited from my grandmothers. So these land plots were sold because I don't need them. And they were sold under the certificates certified by notaries. And under the civil code, if I sold them and registered everything in accordance with the legislation, I have the agreement certified by the notary, then I don't have the right of ownership any longer. The people to whom we sold the land plots are the residents of that village. It seems to me that maybe they have not registered their ownership. Because you know the way the register works. Well, I know how it used to work, the electronic register of land plots. Yes, if they did not register their ownership, that's probably the case for my still being the owner. I addressed the tax authorities. I wrote a statement and asking to take into account that here is the property I own, and I provided the list of confirming documents. And by the way, I never expect taxes charged by the tax inspection for a year. I mean, I do not consult the data of the tax office. I always rely on my own data, but still they do not consider, the tax inspection does not consider these plans to be my ownership. So that's what we can see. Okay, now we have a full-scale aggression from the Russian Federation. And we know that in 2013, in the period, actually not 1 year, but over the period of your judicial career, you have passed at least 13 or 16 judicial acts in Russian, and 2 of them in 2022. We checked the data of the registry, the Unified State Registry of Judicial Decisions, and it says that there are 2 resolutions in one of the cases dated the 10th of May 22 and the 17th of June 2022. And this is the dispute. This is one and the same case. This is the dispute with one of the residents of the Russian Federation located in Novokuznetsk, Kemerovo region. And these decisions are the ones about the appointment of a judge of a case for hearing and summons to the court. So these are not cases, not decisions on the merits of the case. But this does not remove the question why the decisions were made in Russian, and is there any equivalent of these decisions in Ukrainian in the registry? I'd like to mention in this respect that it's really true that the information you're indicating corresponds to reality, but we should understand that there is some specificity of working with the issues when a participant of the proceedings, commercial proceedings, is a foreign entity, which are counterranges under foreign economic activity agreements who are non-residents of Ukraine, and in this specific case, we mean a non-resident of Ukraine who is staying in the country which is the CIS country. And Sumy is a frontier region, and a lot of our companies used to supply Ukrainian products to the CIS countries, and they obtained money for these products from those non-residents. Let me mention that the suits are filed in Russian in such cases, and that's why the parties ask to give summons in Russian and to produce some documents in Russian, because this accelerates the process. The dates are May and June 2022. Our region was under occupation till the beginning of April, and a lot of companies were closed. A lot of people left the region. We had problems with salary payments. And when lawyers addressed us, they wanted to have quick summons issuance, and it was all about charging the money from non-residents, Russian companies in favor of Ukrainian companies. I'm a practical person, and I'm a lawyer. I always obey the law. That is the right of the party, which is envisaged, was envisaged in the provisions of Article 17 of the Convention on the Legal Assistance and Legal Relationship in Civil, Family, and Criminal Cases, ratified by Ukraine by the law of the Verkhovna Rada in 1994. Also, the right to have these documents in Russian for relationship with non-resident countries and the members or the citizens of non-resident countries is guaranteed by Article 1 about the agreement on settlement of the disputes related to commercial activity, which has always also been ratified by Ukraine. It was ratified in 1992 by the Verkhovna Rada. So you must know, as professional lawyers, that international legislation ratified, or rather the norms of which have been ratified by Ukraine, are a part of the national legislation, which means that in this case I was using special norms, and the parties are entitled to this. We, as judges, were very much concerned about it. I cannot apply arbitrary judicial will in the application of the law. I'm not a lawmaker. I'm just a follower of the law. Okay, Yulia, thank you. We understand your answer. Just have you passed any decisions on the merits of the case in Russian in those cases? No. Could I still, I'm sorry, but could I still continue? This issue has been settled by the lawmaker, and this happened only in December 2022, when Ukraine left the convention I've mentioned, and in January 2023, which is a month ago, we stopped applying this convention, and now there is no right of the parties to demand any documents in Russian. Okay, let me give the floor to my colleague, Tad Zachachny. Tad, you're welcome.
Yes, good morning, Judge Dzhepa. I notice from the information that we received that you have passed a number of relatively recent qualification examinations. You, of course, went through the requalification assessment of judges in July of 2018, and that was conducted by the High Qualification Commission for Judges. In addition, you took part in the competition for a vacant position on the Appeals Chamber of the Supreme Intellectual Property Court. Again, a competition conducted by the High Qualification Commission for Judges. And in both cases, you successfully completed the testing that was involved. In the second matter, you were allowed and presumably wrote the practical test, but the competition was suspended, and I'm assuming that's because the operations of the High Qualification Commission were terminated at that point in time. My point is this: you obviously have a significant familiarity with the process that was used by the High Qualification Commission for Judges. With that experience, I wonder if you could comment, please, briefly, if possible, what you consider to be the strengths and weaknesses of the former HQCJ processes, and perhaps give an example of one or two priority matters that you would recommend be changed.
Thank you for the question, Mr. Dzhepa. I would still like to draw your attention to the fact that I was really taking those competitions. I was a success. And I must say that there were no questions I had to the methodology and to the stages the candidate had to pass. I think that the methodology, and as far as I understand, this methodology meets the formal approach to assessment, and the stages were rather reasonable, were well-grounded. In particular, I liked the testing to check knowledge of the law and practical assignments. Well, I have some minor issues concerning practical assignments because I'm a practitioner and I know that these practical assignments were created through combination of several real cases, and that's why there were some minor discrepancies within the practical assignments. For example, I saw this when the explanations of the third party had something to do with the requirements of the writ, but that could not be the case because the third party could not in any way affect the decisions. I mean, in the resolution, you cannot tell about the explanations
I think
of the third party.
Excuse me, I'm going to interrupt you because that's too much detail. I would like a larger picture, please. And that actually brings me to my second question at this point. Those were, if there were ever such things as normal times for the high qualification work, because of course, even in those years, they were under a great deal of pressure. But that will pale by comparison to the huge workload that the High Qualification Commission, and therefore you, if you are appointed a member of the commission, will have to face. You have no doubt heard others say, if you don't know it yourself, that there is a huge number of vacancies to be filled. There are requalifications that need to be done, and there are courts of appeal vacancies as well as the first instance courts. What would you consider needs to be changed, if anything, with respect to the methodology and the process of the High Qualification Commission to meet the extraordinary amount of work that has accumulated while there has been no commission?
Thank you for the question. I would not change the stages. Let me rephrase it. As far as this qualification assessment is concerned, the types of tasks, I mean the test, IQ skills, practical assignment, I would leave it as it is, as well as psychological testing, because I saw that this is a very good tool for evaluating the candidate. I would just have some inventory making in terms of correspondence of some of the test items and some of the practical items to check whether there are no discrepancies in them. I would also change the format of judicial dossiers and other documents, because I would arrange the electronic format of these documents, maybe for some minor elements where we would require some written documents, but otherwise it should be electronic documents for us to be able to quickly access the information about the candidate. And by the way, as far as organizational issues are concerned, I still have some questions concerning the limits of discretion between the HQCJ and the PIC, because this discretion should be clear for us to be able to avoid dead-end situations when there is some battle about a certain candidate. I mean, there could be some discussion, but there must be some final decision reached, and this final decision should be well-grounded. Why in favor of the candidate or why against the candidate, either on the part of the HQCJ or on the part of the PAC. So the determination of those limits of discretion is within the lawmaking process, but as far as I understand, the Commission can also suggest how this what it will look like. This is important.
All right. Thank you for your answer. I noted with interest your role as the judge speaker for your court. And many candidates have commented upon and suggested that one of the ways to improve the public confidence in the work of the HQCJ and its process of selecting judges is transparency and greater communication. With your role as speaker, and your experience, as you have outlined in your opening remarks, with communication for your court, what would you suggest as some new ideas for the HQCJ to communicate better its work with members of the public?
Thank you. Well, first of all, that would be about holding some briefings in case there are some acute relevant matters. You could have a briefing, you could appoint a responsible person, a responsible commissioner with the required skills, who will be a kind of a communicator with mass media and with the representatives of the public. I understand that this was done at the regional level, but at some point of time we introduced some procedures that were really useful. And really later, after we had some surveys in our court concerning the work of the court, we had rather good indicators, good figures. And by the way, the ranking of the court, according to civil society organizations, was also high. I could actually give some specific examples, but I don't think that there is need for that. And let me also mention that if there is a certain acute issue, urgent issue, why not have a briefing? Why not answer the questions? The answers, of course, should not disclose any confidential information, but they should and can create the right impression and rectify some mistakes in the perception of some issues. For example, we had a briefing with journalists. Well, not just one briefing, but these were their events aimed at a legal awareness raising for journalists, because these are people with a high education, they're well educated, but they are not knowledgeable in some of the issues because these are specific legal issues.
Yes, I'm not so much interested in the communication in your court. I'm interested in having you focus on the ideas that you might have to increase public communication by the HQCJ. Do you have any specific suggestions? Would you support the appointment of a speaker for the HQCJ? Would you have a communication committee of the HQCJ? Would you hold regular monthly public information forums? Ideas like that.
Well, that's a very good idea, and I would say that the Commission is a joint body, so it would really be good for it to have a, well, not a press secretary, but a person, because a press secretary is a separate position, but a person who would be responsible for communication with the public. That would be really useful for the Commission, I would say. This person may have some assistance, some media team.
All right. No, I think I have the idea. I probably answered my own question, for that matter, for which I apologize. I'm going to turn you over to my colleague, Judge Markman, and I'm sure he has some questions for you as well.
Thank you for your participation, Judge Dzhepa. Very much appreciate having you here today. We're late in the day in our selection commission process, and we have to make some hard decisions in the very near future. And here's my concern. I've looked at your motivation, of course, and to me, some of the most important questions are number 1 and number 8, speaking about why you're involved in the competition. And I see you saying a number of things. I intend to realize my own ideological and civic qualities. I believe I can be useful. I have the appropriate qualities. I wish to join the formation of the process. I consider it useful to combine my experience. These are all good things. And I am persuaded, and I only speak for myself, but I am persuaded that you're very professionally competent for this commission. And of course, you've supplied a lengthy response on some of the integrity issues, and we'll look at that in the very near future, too. But my question is this. Even this morning in your opening statement, you said, I wish to improve myself, and I wish to have a good professional experience, and I want to become part of a powerful team. That's all good, too, and that just confirms that you genuinely do want to join the commission, and I respect that. But you also say, I've always supported new technologies, and that, too, is good. But I'd like to know, have you always supported judicial reform? That, to me, is the issue here. That, to me, is what's going to make the best high qualifications commission, and I'm just not clear about that. I see many words, and it's not just with your application. I see it on many applications. I see a lot of words, and it's our job to distinguish those words that are genuine and meaningful and those that are just words. So let me ask you, first of all, what is your history of support for judicial reform? What is the history of your actions in favor of judicial reform? If you'd share that, I'd be very appreciative.
Well, thank you for the question, Mr. Markman. Let me mention that if we have an insight into my professional career, I always participated only in the selection processes that were conducted in accordance with specific commitments of Ukraine to the international community. And I was appointed the judge following the procedure which meets the international standards. I had to deal with the selection processes that were conducted for the sake of improvement of the judiciary. Please pay attention to the fact that these were not always the highest, the top judicial bodies. These were just the ones I was interested in. That was the Appeal Chamber of High Intellectual Property Court. And you have my scientific papers mentioned in the judicial dossier, and you can see that even before the code, the amendments to the code were introduced in 2017. These are the amendments related to e-court and other things, and that meet the international principles. So a lot of other principles of registry, maintenance, and other things, which are the elements I had been dealing with. You can find this in my scientific papers, and these are also elements of the judicial reform. And the codes introduced in 2017, the amendments introduced, included my ideas as well. I have a lot of publications related to the European integration of Ukraine, and all my activity shows that I've been methodologically establishing contacts, systemically establishing contacts with the international community. I visited the respective institutions, which I also mentioned at the beginning, and this was with this goal in my mind. And being the judge of the commercial court, I cannot do anything more than I can just do here. When there only appeared the institution, the notion of judge speaker, we introduced this position in our court right away. So these are all the steps, all the novelties we're introducing to improve the courts and to be a part of the judicial reform. And we are responding to the requests coming from civil society and from international partners all the time. Thank you.
Well, if we place you on the commission, what kind of commissioner will you be? Will you be a commissioner who favors incremental reform? Will you be a commissioner who favors more radical reform? I mean, what is the legacy you'd like to leave on the High Qualification Commission if you're placed on that? How will things be better in Ukraine if you serve on this commission? In 4, 5, 6 years after you work on the commission, what will you have contributed? What will we be able to say has been achieved because Judge Dzhepa was on the commission and not someone else? You're competing against good people, of course. You're a good person. You're a qualified person. It's not good people competing against bad people. It's good people competing against other good people. What is your strength? What is the legacy that you will leave on the commission? And how do we know that we won't be making a mistake by putting you as opposed to someone else on the commission? To me, that's the dominant consideration that we have to face today.
Thank you. I understand that this is your major concern about the candidates that are going to be appointed members of the HQCJ. The point is that in my specific case, appointment for the HQCJ for me will not be a situation when I just come, stop performing my duties, and that's the moment when I stop being responsible for what I've done. Every judge is just sent to this commission, and after I'm a member of the commission for a certain number of years, I will go back to my judicial community. And if I don't improve this judicial community but make it worse over this period of time, I will not be able to live in this community. That's why I don't want to make the judicial community worse and the judicial environment worse. I definitely want to make it better, because I will have to go back to it and to be accountable for what I've done. And I will keep communicating with the society, with civil society, with the international community. That's what I know how to do. I've got the skills for that. And I've got a certain vision on what the judge should be like. For many years, I've been in this system, 17 years. And I know what a judge, a professional judge, should be like. He shouldn't be over-emotional. He should meet the principle of legitimacy and obey the laws, which is sometimes difficult. Suppose we address this issues of passing decisions in Russian, but these were not decisions, these were just summons to court. So these are practical issues. This judge should be about emotions. And I would like to make this environment, this community clear for people. And I want to make it healthier, more sound. And I want to make my country better. That's what my husband is doing now. I did not indicate this in my motivation letter, but in March he just went as a volunteer to the armed forces of Ukraine. He took the weapons and went there. I've always also been staying in this city. I have been helping people, and I'm not ashamed of watching into the eyes of the people who are in my proceedings and who are in my city, and I will not be ashamed of watching into the eyes of the people who will lay this great mission on me. Thank you for the question.
One more question, please. You speak much in your motivation about international standards, and as you indicated, you've met with the judges from all over the world, and you have some very valuable perspectives from those. But tell me, what are the principal deviations in Ukraine from international standards. What do you see as the weakest parts of the Ukrainian judicial system in terms of international standards? Because you speak of elevating Ukraine to international standards, which of course is perhaps the principal purpose of the new High Qualifications Commission. What are the deficiencies or the weaknesses and flaws in the current Ukrainian judiciary that you hope to perhaps give the most attention to elevating?
Thank you for the question. Even the Consultative Council of European Judges, which makes regular opinions, has indicated there is no unified recipe for the evaluation, for the assessment in a specific country. It makes regular reviews of the standards which are applicable in different countries, and it has reached some conclusions. And by the way, I've also drawn the same conclusions while watching the Ukrainian judiciary. I've already mentioned that some countries have just a formal approach to assessment and some countries have informal approaches. So, according to my observations, the countries with a well-developed judiciary, in the positive sense of this word, and with well-developed civil society, have different approaches than we have. Informal approaches. I would like the Ukraine to have those informal procedures in future, but that can take place only when we have a very high level of trust in the judiciary. Now we cannot do this, and I think that now, unfortunately, we still have to deal with those formal procedures like testing, civil society control, practical assignments, but that is on a temporary basis until we revive the trust.
Okay, thank you again for your thoughts and participation, Judge Dzhepa. Let me turn to my colleague, Mr. Broekhuizen.
Good morning, Judge. If I look at you, I'm quite sure that you have been looking at earlier interviews to prepare yourself. Is that correct?
Sure.
You no doubt have seen that I'm always going on asking questions about corruption, etc.
Right.
You have also
that is
seen,
your profile.
Yes, it's my profile. That's I think that the reason I was hired for this job. And you also have seen that there are not many judges who've experienced corruption in their court. Correct, huh? So tell me, how is this in your court?
Unfortunately, in the commercial court of Sumy region, we have had some cases when we had suspicions against judges. That was before I was appointed a judge, and over the period I've been a judge here. These are the facts I cannot cross out. They really occurred, and that's why in 2018 we started our communication campaign, because there was a desire to still mention that if there is a certain disease of some parts of the body, if there are some suspicions against some announced in relation to some judges, it doesn't mean that you should stop the functioning of the court in general, because in the same court there may be good specialists, good judges who are people of integrity, and you cannot just do it like in the Middle Ages, like to stop functioning of all the judges of that court.
No, I wouldn't be in favor of that.
So I've heard about things like that, but I was not involved in the respective events.
No, I wouldn't like to bring you back to the Middle Ages. That's a very bad idea, of course. Did you look at the interviews of yesterday?
Partially.
Okay, we had a lady judge. I will explain to you.
but I don't remember any questions about corruption. I didn't have too much time. I was at workplace, so I didn't see any questions related to corruption. If you can, please ask your questions.
Well, we had a judge yesterday, a female judge of, I don't know, and she was driving a Polo Volkswagen of quite some age. And I asked her why she was driving a Polo Volkswagen. That's one of the few judges we have seen, because all the judges seem to be driving enormous cars. Not only the judges, but also their husbands and wives. And then she explained to me that during the interview that she didn't understand the question, because she was a judge of the first instance, and didn't have such an enormous income, so she couldn't really buy another more expensive car, and that was the reason she was driving this Polo. And can you understand that when I look at the information that have been provided to us, that I see a lady who has, let's say, much less experience than the lady we interviewed yesterday. You have a husband who's in the army, which is of course very good of him. But in the information that is provided to me, I see that he had an income which would took, let's say, at least 6 years for him to earn the value of the car you bought from the US, without then also taking into consideration the amounts to be spent on living, etc. And I'm not going to discuss with you whether this was possible or not, because you explained that to my dear colleague, Judge Metchensev. The point is, if you look at it with my eyes, then I get difficulty to believe that you should be selected, because there is a problem there. You understand that?
Thank you for the question. And I would say that we should make conclusions in retrospect in relation to judges. If you have a look at my declarations over the whole period when I was a judge or civil servant, I got most of the questions because I always declared everything. I was not trying to register any of my property in the name of my grandmothers, grandfathers, mothers-in-law, and other things like that. I always declared all my property, and I always sold it and bought it on legal grounds. And even if you can see, I provided the confirming documents. I keep all the documents because I understand the degree of publicity of this position. I don't think that we are not on equal terms with the judges of trial courts. Well, there may be some minor difference, but you see, I have about 1,200,000 hryvnias a year. And after the qualification assessment, I would say that we started getting quite large amounts of money. And it's not possible to say that a judge doesn't have the money. It would not be absolutely right. I mean that, of course, we have some costs and expenses. Maybe this person really has the costs which do not enable her to buy another car. But I came to the position of the judge already having some property, and you can see this. I had everything. I had an apartment, and I still live in this apartment. I don't have any other property. I don't have any houses which I built. I like cars, and that's like my habitual family feature, because my father and my grandfather were pilots, and they like technology. And since the age of 18, I've been driving a car. I like cars. But you can see that these are not absolutely luxury cars. I'm not a VIP client of large cars saloons. These are used cars, but just I repair them. And I think that they fully correspond to the level of my income. I earned always more than my husband, unfortunately, though he has some property he had before marriage. And he has some property. He has parents. I have parents, and they are helping And by the way, my father used to be the commander of the civil aviation unit, and you understand that that was quite a lot of income he had. And these are high-level specialists, top-level specialists. Unfortunately, now he's sick. He has a very unpleasant disease, and he's in a bad situation. But otherwise, he could be earning now about $10,000 or $15,000 a month. I always had everything necessary. So I think that if a person comes to the judiciary with a certain background, and the person will not have the striving and the ambition to earn something illegal or to have any luxury cars or have any luxury buildings. And this is even good, because this means that this person will keep working without thinking that he or she needs something special to buy.
Thank you. Thank you. It was a very long answer, and I understand, of course, what you're saying. The point is that we have to make decisions, and it's not only because everyone tells us in this competition that they are in order and there's nothing to worry about. We have had endless explanations about cars and land plots and houses, etc. As is it with you? But I understand your explanation, and I would please like to pass the floor to my dear colleague Sergi. Judge Fernandez, sorry.
Дякую, пан Роберт.
Thank you, Robert.
Пані Юлія, доброго дня.
Good morning, Yulia.
На заповнені декларації щодо майна.
You've been focusing on the declarations, and let me ask you a question in this respect. As you can see from the materials, in your declaration, paper declaration of 2018 or 2015, you mentioned that your salary is 193,000 and something for the year. But in the electronic declaration for the same period, you mentioned that your salary is 182,000 and something. Could you explain this difference with more than 11,000? Well, thank you for the question. The question is absolutely reasonable, because civil society organizations paid attention to this, and thank you for raising this question for me to be able to provide the explanations. I'll try to provide a brief answer. You understand, I'm a lecturer, and that's why I provide some extensive answers normally, but I'll try to be brief. You remember that judges had to submit paper declarations before 2016, and in 2016, e-declarations were introduced, and for 2015, I submitted their declaration following the list that I was given by my court. I showed the amount with no deductions of taxes and other things. That took place because the paper declaration still was to comply with certain rules. I had to indicate full income. In August 2016, the NACP provided or published their explanations on the filling out of these new electronic declarations, and that was a repeated declaration judges had to submit, because we had already submitted the paper one. Yes, it's clear. And in those explanations, in items 45 and 46, you can find them on the official website of the NACP in the version in which they existed as of the 11th of August 2016. And I submitted the declaration in October, if I'm not mistaken. This was the first stage of declaration. And it was mentioned in Article 45 and 66 of the explanations that for declaration purposes, the money paid by the employer to the subject of declaration for covering the costs of business trips are not to be included into the declarations. And I provided to the Commission my list for 2016, and you can see that 11,000 and something, I don't remember exactly, were the costs of my business trips, and this is exactly the amount attention was drawn to by civil society organizations. So these are business trips fees. I'm a formal person. I always understand the law literally because I think that this is the right approach if there are no grounds to do it in any other ways. That's why I made my electronic declaration, not including this 11,000 that I spent on business trips. Yes, but you declared your salary and separately you indicated the business trip costs. So what?
А чому?
Not exactly. Since the NACP mentions that business trip costs are not considered to be income, I just did not include them. But that was your income for the year. Yes, it was my income, but under Article 646, this money is not considered to be the income. You don't have to declare this money. That's why I didn't include them. But the electronic declaration didn't have any separate section business trip costs, fees, or that's why I didn't mention this amount at all. Okay, it's clear. We've got the answer. And also, let me ask you the following question, which is related to the questions the civil society organizations have for you. One of the questions has been already asked by Mr. Yevhen Mesens and my colleague, and we still have a couple of questions. So here is the first question civil society organizations have. You passed a decision in the case 920 fractions and something. The case was in November 2014, but you were not at your workplace. You were on vacation. So could you provide any explanations on how could the decision be passed during a vacation and how it was introduced into the registry? Because we checked it in the registry, and it's true. There is a decision on issuance of a document and initiation of proceedings. So could you please give the explanations in brief? So I also opened this statement, this decision, since I don't remember all the documents. I've got thousands of documents over this period. That's why I opened the unified document flow system of court, where we have full data about who created the document, who signed the document, when it was created. So over that period of time, we didn't have electronic digital signatures. By we, I mean judges. We were not signing the documents which were sent to the registry. And documents were created by assistant judges and sent to the registration. Judges just had to sign the documents physically, manually. So civil society organizations claimed that I was on my vacation. But let me adjust this information a little bit. That was Monday, and that was the only day, just one calendar day. According to the table of my work days from ISDS, the automated case flow document system, that was just a one-day vacation. There was no court hearing on that day. And you know that the decision to initiate proceedings in the case is something that is passed not on the basis of a court hearing. You just indicate the date. This is a procedural decision. Yes, sure. And you don't need a court hearing for that. And the date on that document could be any within 15 days after this decision is made. That's why I got this file, this writ on before, several days before November the 6th, and that's why the period was actually expiring on the 11th of November. There was no need to do this on the 10th. It could be done on the 11th. I think that this document most probably was physically signed by me the next day, on the 11th of November. But maybe I didn't notice that the date was different. How does the document go to the registry? According to the ISDS data, well, we know how the documents get to the registry. The main problem is that on the 10th of November, this document, procedural document, was introduced into the unified registry of court decisions, and that's why civil society organizations have the question, why was it happening if you were on vacation?
Вот в чому питання.
That's the problem. Yes, thank you. According to the data of the automated system, this document was created by the Spak Maria, who is the secretary of the court hearing. I cannot ask her because she has not been working in our court for several years already, but she created this document and gave it the status of the original. It's not indicated that the document was signed on that day. The document cannot be adjusted or edited after it gets this status, and it just automatically goes to the registry. And it was not necessarily signed on that day. Thank you. Thank you. We've got your answer. We don't have time left. Just one more question asked by civil society is the question related to the following. You were born in Russia, and you got the citizenship of Ukraine only in 2015. 2005, I'm sorry. And the question is as follows. Are you maintaining any relationship with your relatives or any other people in Russia? And have you visited this country over the period since 2015? Thank you for the question. Let me explain some formal issues. As I've mentioned, my parents are Ukrainians by origin, and they were born in Ukraine, the same as my grandmothers and grandfathers. They were born here. But after graduation of the aviation college in Kremenchuk, my father was directed to work in the territory of the Siberia. Unfortunately, there was a practice like that. So in Turai, in Tyumen region, I was born. Of course, I cannot influence this fact. I was born there, but at the age of 15, since my parents wanted to get back to Ukraine, they got back to Ukraine, and I was 15. At that time, at first I was sent here, and then they also came to Ukraine. And since 2000, I've been in the territory of Ukraine. I had my studies here at higher educational institutions. And the point is that in Russia, the child gets his or her passport at the age of 14. And I automatically got Russian passport. But when I came to Ukraine, well, there was just no other option. That happens automatically. The same as the fact of my birth. I cannot change it. But when I came to Ukraine in 2004, which is almost 23 years ago, I've been permanently residing in the Ukrainian territory. And you know that getting the citizenship is the process which lasts for some time. There is a procedure you have to follow. I studied the language. I studied here generally in 2004. It was the only time when I went to the place of my previous citizenship to get the list of all the documents which were necessary to withdraw from the Russian citizenship. These were some certificates of on the absence of criminal record and other things. I provided those documents to the Ukrainian authorities, and if I'm not mistaken, in June 2005, I got the passport of the citizen of Ukraine. Okay, thank you for your answers, and let me give the floor to Ivan, the chairperson. In your motivation letter, you mentioned that it is necessary to implement the best world practices in this field, meaning in the field of selection of judges. What kind of practices do you mean? Thank you for the question. Let me get back to the answer I have already provided on different selection procedures. I mentioned that there are formal and informal procedures like we have in the UK, which is a well-developed country with a well-developed judiciary. We should still have formal practices, and there are even some countries which generally don't have any selection, like Switzerland, but we know that Switzerland is also a very well-developed country. So what have already said is that unfortunately now we still have to apply those formal procedures. I mean, selection, assessment, testing, performance of practical assignments, interviews, verification conducted by all the controlling bodies and the civil society. But when we overcome all our problems related to lack of trust, we may reach the stage of informal procedures, which are better inherent in democratic countries. Yes, that's what I was clear about, but I wanted to specify some things because there is a paradox, you know? The best world practices, the very expression means that our practices are worse. If in Canada, in the US, or in the UK, you suggest having some interviews with judicial candidates on YouTube, or in case you suggest placing the declarations of judges on some official channels, you will be deported from that country and you will never be allowed to go there again, or at least you will not be allowed to make speeches there. Of course, it's a joke, but still, I mean that they will not tolerate such things. And almost all of the procedures in those countries are rather informal. They don't have YouTube interviews. They have a rather closed process. The public is not interfering that much because it's not interested in this process. And if you ask knowledgeable citizen how a good citizen how you can become a judge in Canada, I don't think that he will be able to explain to you because he's not very much involved. In Ukraine, this process is very much open, and all the candidates claim that it should be even more open and transparent. So who has got the best for the best international practices? We or they? Well, thank you for the question, and also have partially answered the question. I've mentioned that there is no single recipe. The practices of formal approaches which are now applied in Ukraine and this multi-layer assessment and attention from the society and taking into account all possible opinions. And, well, we have a lot of information which is disclosed, and in other countries this information would be considered to be confidential, I would say. So there are differences, but we should be striving for the best global practices, and I think that after such formal procedures, because we are now in the crisis situation, we have a crisis in the judiciary, so I think that we will select people who will contribute to the improvement of the situation when finally we won't have the need to apply for formal approaches. We will reach the level of trust which is high, and we will be able to deviate from formal procedures. You need to believe in your state. You need to have respect for your state. And, for example, in the US, this respect for the country, for the state, is cherished very much. Yes, but that's a wrong discussion. I mean, it could go us into different sides. But if you are appointed a member of the HQCJ, if I were you, I would ask colleagues from other countries to introduce the notion of YouTube interviews. Let's see how they respond to that. Just imagine that you have qualification assessment of a judge of an appellate court, and during the qualification assessment, you get some information, reliable information, authentic information, saying that in the scientific paper of this judge there is some plagiarism. What would be your actions? Well, I think that this is bad if we focus on the criteria of integrity, because integrity is not just about performance of the duties by the judge, ideal performance of his professional duties, but it's also about his conduct beyond the proceedings. So this is integrity. Integrity actually in Ukrainian consists of two components, two words. So it's not just about professional integrity, it's about conduct and integrity in life. And I think that this has a negative effect on the criteria of integrity of judges. If we apply some ranking procedures, and by the way, here we could talk for hours concerning whether we need ranking procedures or not. And I think that during special interviews or assessment procedures, this ranking is something good, because everybody will see what the points are given for, where from you get a certain number of points. But in general, ranking for the judiciary is not a good thing because it actually interferes with the independence of judges. Okay, thank you. Are there any other questions?
Пані Юлія, будь ласка,
Юлія,
ваше
Then
завершальне слово
please
на
your
свійській
concluding
бесіді, будь ласка.
remarks at this interview. Well, of course, I would like to express my gratitude to the commissioners for this selection process. It is the experience which is useful for me, for our state in general. That's why let me express my gratitude to you. And I really highly appreciate your work, not just because I'm the candidate, but because I can see that you are following the principle of procedural justice. You're listening to the civil society, you're listening to the candidate, and you're making your own conclusion, final conclusion. And also, I would also like to wish the candidates who will win in this selection process, in this very difficult race, to work for the benefit of our country, because the country is really worth this effort. And everything we now do actually reflects the attitude of our nation to our future. Let me wish you, as members of the selection commission, and let me wish all the candidates who do not become members of the HQCJ to be inspired in their work, to have some interesting future projects, and see you maybe in some other projects. Thanks a lot to all of you, and I would like to wish all of you our quick victory, for our relatives to go back to our families. And let's stay in peace and in
Дякую,
well-being.
пані Юля.
Stay safe. Thank you, Yulia.
На цьому наша співбесіда
That's the end of
завершена.
our interview.
Дякуємо вам за участь.
Thank you for
Всього
your
вам найкращого. І ви
participation.
також
Good luck
бережіть себе.
and
До
stay
побачення.
safe. Goodbye. Goodbye.